Good morning, all. This application hearing is in the matter of CFI 030-2025 and is being held by way of video conference before His Excellency Justice Mark Pelling, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Holman Fenwick, William, Middle East. Lead counsel is Mr. Max Marenbon. The defendant is represented by Trowers and Hamlins. Lead counsel is Mr. Gregor Hogan. Thank you.
Good morning, everybody. I hope you can see and hear me.
Good morning, my lord. I can see and hear you.
Very good. Mr. Hogan, this is your application.
Yes, thank you, Your Honour. I appear for the defendant/applicant, Cron AI, and my learned friend, Mr. Marenbon, appears for the claimant respondent, Alarabi Investments Limited, who I'll refer to as AIL. I hope Your Honours receive skeleton arguments both from myself and Mr. Marenbon.
All right, let me tell you what I've got, and then I'll make sure I've got everything.
Yes.
I've got a skeleton from each of you, which I've read. I've got an application bundle running to 726 pages. I've got 2 statements of costs, and one of the parties has sent me a copy of the obligations law and the contract law.
I believe that is everything. That the pagination matches mine in my bundle, so I think we're working
Excellent.
there.
All right, now just so you are aware, page 460, for example, is 468 in the bundle, so it looks like it's about eight pages adrift on the PDF counter.
I see. Is that perhaps to do with the index at the beginning?
I think that's right. That's right. It's nothing
well,
more than that.
I'll try and add 8. I'll try and be quick with my mental maths and add 8 onto all the page references.
Okay.
Very well. Your Honour will recall from the directions that you made via the registry that there are essentially 2 broad matters before Your Honour today. The first is whether Cron AI's application to set aside default judgment has been effectively withdrawn by its notice of discontinuance, and if not, whether it should be granted permission to withdraw it today. And an application notice to that effect was filed last week out of an abundance of caution following Your Honour's directions. And then secondly, if Your Honour is against Cron AI on those 2 points, whether the court should continue to consider the substantive set-aside application today. And Your Honour has indicated that may well be a case of timing and what we have available as much as anything else. Can I ask, is if I proceed on that footing, addressing discontinuance and permission to withdraw, and then perhaps allowing my learned friend, Mr. Marenbon, to respond, would be the way that Your Honour would wish to proceed?
I think that takes care of the first part of the day. I
Great.
agree.
Excellent. Well, then I'll proceed on that basis. By way of background, my learned friend and AIL would want Your Honour to believe that this is a very simple case of a debt claim, where the debt has been informally, open quotes, accepted, end quotes, by Cron AI. In particular, my learned friend refers to emails that are found in the exhibit to Mr. Berganza's first witness statement. He's the partner at HFW with conduct of the matter on behalf of AIL, which he says shows 16 supposed acknowledgements of the debt in question. The picture is, however, in my submission, much more complicated, and most importantly, the formal response that Cron AI has made to the claim by way of its set-aside application, insofar as it's still active, has always been that the debt in question is not admitted and the claim will be defended in full. My learned friend says the basis for
can I just ask? Can I just ask, because
yes, of course,
it's a point which is made by your opponent. Are you able to tell me what, in very brief and broad summary, the defence is?
Yes. Your Honour may have seen that a reply witness statement came in from Mr. Chabra on behalf of Cron AI late last week, I can only apologise to the court for that coming in late, but it has been filed again in light of your Honour's direction that you may go on to consider the substance of the set-aside application today. The basic point is this. As I can go on to develop, Cron AI says that the circumstances in which the loan was extended in June 2024 were in circumstances where it was in a position of acute financial distress with operational cash flow in serious jeopardy. They say, Cron AI maintains that that situation was the result of conduct by AIL through Mr. Al-Gaith, its principal, in circumstances where he made repeated promises of funding to Cron AI. Cron AI jettisoned other funding opportunities as a result, such that by June 2024, in fact, as early as December 2023, it was in, as I say, in under acute financial pressure, such that it had no option but to accept the loan. And those circumstances in Cron AI will maintain in its defence gave rise either to a threat under Article 41 of the contract law, or alternatively, the loan was entered into, as well as various other agreements, as a result of misrepresentations within the meaning of Articles 29 and 30 of the obligations law, and giving rise to loss. I see my learner friend has turned on his microphone, so I'm anticipating he's going to say something.
Well, my lord, I'm so sorry to interrupt, Mr. Hogan, but that statement reached me at 7 minutes past midnight UAE time on Friday. It had come to my solicitors, I think, shortly before midnight on the Thursday. It's come far too late. There's no good reason why the court should grant relief from sanctions. I'm not prepared to deal with it. I'm not prepared to deal with it today, but I'd also be inviting the court not to admit it and not to grant relief on this occasion. If my learned friend's submissions are going to be put on the footing that now forms part of the evidence before the court, and that the defence is the defence that's now being put, then I'd ask the court to determine the question of relief from sanctions as a preliminary matter, because I do have submissions on that.
Yeah, I'm all right, but the reply statement's in the hearing bundle, isn't it?
Well, it was unilateral, as far as I'm aware, unilaterally added to the bundle by the defendant who's prepared the bundle. I mean, that's.
I see, and so the bundle, but you didn't get the bundle because I downloaded the bundle at the weekend. I have to admit, and prepared prepared it over the weekend. But anyway, so you didn't see the bundle until when?
Well, I got the bundle on Friday, and I think the most recent version of the bundle was filed and provided to the parties at 14:29 on Friday. As I said, I got the statement reached me at UAE time 7 minutes past midnight on Friday. So I suppose UK time, looking at night, 7 minutes past 9. I think it had come to my solicitors about 45 minutes before.
So after close of business in London and after close of business in the UAE.
Yes, my lord.
Well, that statement is material, isn't it? Only to the question, only to the merits of the set-aside application in its current form.
Yes, my lord. I mean, I think the defendant's position is that if that statement's to be admitted, then an adjournment would be.
Well, I think it was referred to at this stage only because I asked what the defence was.
Yes, my lord.
All right, Mr. Hogan, as I understand it, but I may be wrong, the reply statement is relevant to the substance of the set-aside application, isn't it?
Just addressing one procedural point, time point. My instructions are that the witness statement was served on Thursday UAE time, not on Friday. So if it's delayed in making its way to Mr. Marenbaum, then that's not the fault of the claimant. Those are my instructions I received via WhatsApp. It is to an extent most relevant to the substance of the set-aside. On the other hand, in my submission, it is relevant insofar as it said that there is no basis for allowing, for example, permission to withdraw the current set-aside application and permit a further, better particularised application to be filed on the basis that it would be pointless because no defence has been articulated.
So far as that, can I just tell you where I am on that? Because I
Yes,
read that in the skeleton as being an issue. My feeling about that at the moment on entirely provisional basis is that the business of the court today is to determine, as you rightly say, the validity or otherwise of the notice of discontinuance. Secondly, if that isn't effective, your application for permission to withdraw the existing application to set aside. If I accede to one or other of those submissions, then what you do thereafter is a matter for you, I think, isn't it?
Well, yes, subject to if your honour is minded to follow the English authorities, your honour would have discretion to impose conditions on the withdrawal, and my client is prepared to.
Well, yes, so that would be a condition as to costs. But what I don't see at the moment is it's appropriate to give directions for concerning any new application you might make in the future, because that has to be adjudicated on its merits in the future.
Yes, no, I suppose what I was saying, not articulated very well, is that my client is perfectly happy to agree to filing a renewed application within a certain time frame in order to deal with the complaint that there might be dilly-dallying or further delay on its part. So that's all I'm saying. Is
there's a hidden issue which is drifting around between the parties, I suppose, on the skeletons, which is whether you're entitled, if you get permission to withdraw this application, to issue a fresh application without a change of circumstance. And what I'm saying in relation to that is you have one view of that particular issue. Your opponent has another view about that particular issue, but it doesn't really arise today. If I accede to one or other of your primary submissions, it would arise, if at all, if and when you issue a further application to set aside the default judgment.
Well, that would be my submission. Yes, you've anticipated where I was going to go to.
Yeah. All right. Okay. Well, let's leave Mr. Chabra's reply statement to one side for the moment, and see, because, as I say, I think it's primarily relevant to the substance of the set aside, and let's focus attention on whether or not the notice of discontinuance is effective, and if it isn't, whether you should get permission to withdraw your application.
Very, very, very well, Your Honour. Thank you for that indication. If you could perhaps turn up page one of the bundle, which would be your page 9.
Yes, I'm there.
This is the original claim form, the Part 7 claim issued by AIL, which was issued on the 13th of March 2025. That's about 7 months after the loan supposedly admitted was repayable. The default judgment itself was issued on the 14th of May 2025. It was about 4 months later that AIL issued its application to enforce the default judgment on the 19th of September 2025. That's at page 220 of the bundle. Your page 220. No, that's not right. Excuse me. It's on my 211, which should be 209. You're 219, I believe.
Yeah.
This is the application to enforce the judgment issued on the 19th of September, and then at page 288 of the bundle. Getting up. It should be the order of His Excellency Justice Nasser al-Nassar declaring the default judgment to be final and executory, which, as Your Honour knows, is the first step for being able to enforce the judgment in the DIFC and in onshore Dubai through the court's law. The first formal attempt at enforcement of the default judgment, in fact, happened in England in very late January 2026. And no steps have been taken at all to enforce the judgment either in the DIFC or in onshore Dubai. So we are well over 18 months on since the original loan was on AIL's case repayable. And so in my submission, it can't be said that this is a claim which AIL has pursued speedily or with any sense of urgency. And so in my submission, the howls of complaint about delay, for example, that AIL now makes, and the complaint that it would be terribly unfair if it were somehow delayed in taking enforcement action now must, in my submission, be treated with real circumspection. The set-aside application itself was issued on the 27th of March 2026 and was then served on AIL on the 24th of April 2026. The key development around this time is that on the 6th of May 2026, Cron AI approached my instructing solicitors, Trowers and Hamlins, about instructing them as their DIFC legal Part 1 legal representatives. And as Mr. Schouler explains in his witness statement at paragraph 2.3, I don't think I need to take your honour to it, but it's page 217 of the bundle, which I think should be your 225. He explains that Trowers informed the registry of that approach by Cron AI that very same day on the 6th of May, and a Part 37 notice of change of legal representative was duly filed on the 8th of May 2026. In light of the impending deadline for Cron AI to file its reply evidence, Cron AI applied for an extension of time to file that evidence in reply to Mr. Berganza's witness statement, including its 154-page exhibit, because that evidence was due within less than a week of Trowers being instructed. That extension was not agreed to, and an application had to be made for an extension, which was issued on the 14th of May, supported by Mr. Schouler's witness statement. That should be at your page 221 of the bundle. And perhaps I could take you to the part of Mr. Schouler's witness statement, which explains the reasons why that application was made. That is at paragraph 3.1 of his witness statement, which is at my page 218. So that would be your 226, I think, of the bundle.
Yeah.
And if I could refer your honour to paragraph 3.1, as I say, of Mr. Schouler's witness statement, and I think it's perhaps quickest if your honour takes a quick read of that.
So the whole of paragraph 3.1.
Yes, if you may.
Yeah, that's fine. Yeah.
So in my submission, those are quite self-explanatory reasons for why an extension of time was required for filing evidence in the circumstances of the instruction of solicitors shortly before a filing deadline. But in my submission, it's also important for the purposes of the discontinuance. That process of Trowers taking instructions, reviewing the evidence and the background, as well as taking advice from counsel, was always going to impact upon the substance and the prosecution of the set-aside application. The witness statement that was originally filed in support of the application, your honour will have seen, it is a very short document. It doesn't look like a witness statement that lawyers would prepare, but that's of course because Cron AI was acting as a litigant in person at that stage. And indeed, that is then reflected in the reasons that Cron AI advances its application, which, as I say, has been filed out of an abundance of caution for permission to withdraw the set-aside application. That application notice is at page 268 of the bund, my 268, which should be at Your Honours 276.
Right. Yes, I have that open.
So this is the application notice for permission to withdraw the existing set-aside application.
Yeah.
And then if I can invite Your Honour to go down 2 pages to Part C of the application notice, which is the section containing the evidence in support of the application.
Yeah.
And one can see in those first 2 paragraphs, in particularly the second paragraph, that the application is made on the basis that the set-aside application as currently drafted is inadequately particularised, a point that is taken by my learned friend against me, and therefore the best way to go about things, fixing things, is for the application to be withdrawn and a fresh application with the properly particularised application notice and witness statement filed. Of course, the benefit to AIL of that is that the material which is now found in Mr. Chabra's reply evidence setting out the structure of any of the proposed defence will be something that Mr. Braganza or someone from AIL will be able to respond to in evidence, and so there can't be any complaint of unfairness, and the court will have the full picture as to what is in dispute and what's not in dispute before it.
Yeah.
So what Cron AI has done is exactly what in my submission any responsible litigant having instructed solicitors would do. They've taken advice and they've determined that the existing set-aside application is inadequate and would be better off for the application to be withdrawn and a fresh one issued. And as Your Honour will have seen, Cron AI took the sensible position that it would have to pay the costs, accept the cost consequences of taking that course of action, and would pay AIL's reasonable costs of the with discontinuance if the automatic consequences of discontinuance under the relevant parts of the RDC, or now would pay the costs of the resulting from the withdrawal.
Yeah.
Trowers and Hamlin wrote to HFW on the 25th of May asking for their consent to the discontinuance or withdrawal. For your lordship's note, that's at page 300 your page 326 of the bundle.
Just give me a moment.
Let me double check that I've got that correct as well.
That's Trower's letter of the 25th of May.
That is the Trower's letters of the 25th of May, yes. And you can see in the third substantive paragraph in the final sentence, sorry, in that paragraph, there's the acceptance of the cost consequences and inviting discussions to agree what those costs would be.
Yeah.
There was then the interposition of the Eid vacation in Dubai. And the response to that letter was then received on the 2nd of June. And that's at 343 of my bundle, which would be 351 of your bundle.
Yeah.
And that's a HFW conveying AIL's rejection of Cron AI's proposal. The basic objection was that Cron AI's proposal was just time wasting and about delaying enforcement. However, you've heard my submission as to why complaint about delay should be granted little weight when it's made by AIL, given its own tardiness in pursuing this claim.
But in a sense, it's your application to set aside the judgment. So presumably your submission is it's your application. You're entitled to withdraw it. Yes, permission is required, but as long as you concede that the costs of an occasion by the application that's being withdrawn are to be paid by your client, then there shouldn't be any debate about all of this.
Quite. In my submission, now that the permission to withdraw application has been made, there are effectively two routes to getting to the same outcome, because the acceptance by my clients that it will need to pay, quite rightly in my submission, that the cost of the discontinuance in inverted commas is the same whether or not the notice has effect or whether there has been permission to withdraw. And in my submission, that there is no. The submission that's been made is that there's prejudice will be caused, which can't probably be met in cost. But I'll come on to explain why that's not right. Your Honour has seen from my skeleton argument and that of my learned friend. Sorry, I should say that following that letter on the same day, the 2nd of June, is when the notice of discontinuance was filed. Your Honour will have seen from my skeleton argument and that of my learned friend, as well as from the email exchanges that have taken place between the parties in the registry, that there is a disagreement as to whether the notice of discontinuance is effective as regards an application under the RDC as opposed to a Part 7 proceedings themselves.
Well, I'm perfectly happy to resolve that issue if the parties want me to resolve it, but I wonder if it's essentially academic, having issued your application.
That occurred to me over the course of the weekend, and having taken instructions on the costs in relation to the permission to withdraw. My learned friend makes the point in the skeleton that we sort of tried to blow this up into a substantive issue of law that needs to be determined. I can well see the attraction to Your Honour of not having to deal with that point today, when there is an alternative.
Well, I'm perfectly happy to deal with it. I just wonder whether there's any utility in doing so. In the circumstance of this case,
the utility in doing so is if Your Honour is against Cron AI, that there has been a necessary change of circumstances that justify permission being granted to withdraw. There is a disagreement between my learned friend and myself as to whether or not there are the necessary circumstances. So I think it probably is necessary, and I see my learned friend nodding.
Okay.
I think it probably is necessary for me to at least briefly explain to Your Honour why we say the notice of discontinuance is effective. And I do that mindful of Your Honour's preliminary view expressed through your directions. It is accepted by Cron AI that Part 34 of the RDC does not, in terms, refer to an entitlement to discontinue an application, such as an application to set aside a default judgment. As Your Honour knows, the terms of RDC Rule 34.3 are very simple in terms.
yeah.
You can find it is that a claimant may discontinue all or part of a claim. Your Honour will recall that there is a very similarly worded rule under the English CPR in Rule 38.1. Equally, Cron AI accepts that the rule has been interpreted in England to mean that interim applications cannot be the subject of a notice of discontinuance. And for Your Honour's note, the relevant commentary in the White Book is in the bundle at your 682. And the relevant paragraph is 38.1.2 of the White Book. And it was on that analysis that the objection was raised by AIL when the notice of discontinuance was first served on them. And if I can take you to that letter that was sent, that's at my 441, which would be your 449.
Four
449. I think that should be the letter of the 2nd of June.
Yeah.
And if I could ask you to look at paragraph 3, you'll see there that in the very first sentence there is no provision in the RDC that permits a party to withdraw an interim application.
Yeah.
And then later on, there's a reference to the High Court in England having found that there is an implied power to withdraw an interim application again. So the reference there is very much to interim applications, and that was the basis of the objection taken in that correspondence, and then again later in correspondence with the registry.
Yeah.
You'll see there that the reference is made to two authorities by HFW. The decision, both decisions of His Honour Judge Matthews in Ottawa and in Mongolia from 2024, and then an earlier decision in Parrot Pay from 2023.
Yeah.
The first of those decisions is at my page 549. Which should therefore be
my 557.
That's
I should
right.
say, as part of my pre-reading, I read the authority.
That's fine. Well, then I won't labour any of these points. Then that, as Your Honour will recall, that Ottawa was indeed a case about an interim application. It was an application made by petitioners in an unfair prejudice petition for interim injunctions. His Honour Judge Matthews found that the decision by the petitioners not to pursue those applications would not carry with them the usual discontinuance cost consequences found in the analogous provisions in the RDC and the CPR, with which Your Honour is well familiar. The Parrot Pay decision, in fact, is not a case about where the issue of discontinuance was a live one at all. But again, it was a case in my submission properly involving truly interim remedies, because it was concerned with an application to remove interim administrators. It was not a case where any sort of final relief was being sought by the applicant, which it then sought to discontinue. But in my submission, Your Honour, the application which is before you today, an application to set aside default judgment, is not that sort of interim application. The outcome of a set-aside application is an otherwise final judgment is set aside in its entirety. It is as if the judgment never existed. Put another way, the set-aside application seeks no relief other than that, i.e. if the set-aside application is discontinued, there is no other head of relief that remains. Equally,
but I just wonder whether the focus of attention on whether or not the application is to discontinue or set aside an application involving an interim remedy as opposed to a final remedy is the correct focus. Part 34 is, as you say, very clearly drafted. RDC 34.3 says a claimant may discontinue all or part of a claim. Therefore, the focus of attention is on an originating claim, or I suppose a counterclaim. It's not on applications of any sort.
In my submission, it's not entirely clear, which is why it's been the subject of litigation and debate in England and subject to commentary in the White Book. The word claim is not a defined term in the RDC. It's not found in the interpretation section, which is extensive in defining various concepts that are found throughout the rules. Your Honour's reference to originating process is one that my learned friend also refers to, and it's taken from in his submissions from paragraph 15 of the Otto decision, which is at 553 of my 553, your 561 of the bundle.
Yes, I'm there.
And I accept that sort of about in the third sentence, His Honour Judge Matthews refers to that the claim for the purposes of Part 38 is whatever is the subject of the claim form or the other originating process, here a petition under the Companies Act. But later in that paragraph, His Honour refers that continues that the application in that claim, i.e. the petition for an interim injunction, is not itself part of the claim. There is no claim to a permanent injunction. It is simply part of the procedures available to preserve the position until the trial of the petition and the possible grant of a permanent remedy. So I must accept that as a matter of form and substance, that there is that the application notice in this case is not an originating process, but in my submission, this is an application of a different nature from the application that was before His Honour Judge Matthews in that case.
All right. Well, before you go on, do I get some help from RDC 34.4, which provides that a claimant must obtain the permission of the court if he wishes to discontinue all or part of a claim, in which either the court's granted an interim injunction, anyone's given an undertaking, or where the claimant has received an interim payment. In other words, is that provision not consistent only with the scope of Part 34 being limited to the discontinuance of either a claim or part of a claim as advanced in originating claim?
In my submission, it doesn't cover the whole of the ground because, of course, the scenario that we're in, it's not an interim form of injunction that's sought at all. There's been no application for interim relief. There's no holding of the ring. In this sense, as I say, the outcome of the set aside application is a final one. There will be nothing else to happen, if it succeeds or if it fails. Either the default judgment remains in place and in our case would remain final and executory and therefore immediately enforceable and amenable to the enforcement mechanisms under the court's law, or in this case it's been taken off to England for enforcement. And if the application is dismissed, then that judgment remains fully effective, executory and enforceable. So in my submission, it may well be that there is somewhat of a gap between those provisions, and the application before you doesn't sit within the concept of an interim injunction, and therefore the only place in which it could fall would be by interpreting claim to include this sort of application where it's a form of final relief that would be granted on the application. In that sense, it is equivalent.
Okay, but my point was perhaps a simpler one, which is RDC 34.4 is surely consistent only with Part 34 applying to the discontinuance of a claim or part in the sense of a claim advanced by claim form and particulars of claim, because it says in effect that permission to discontinue is not required. You can serve a notice to discontinue unless in the proceedings you seek to discontinue you've either obtained an interim injunction or an interim payment. So in other words, the RDC 34.4 is consistent with and only with discontinuing claims or parts of claims in the sense I meant.
Thank you for the clarification. Apologies for not addressing that head on. In my submission, it is not only consistent with 34.3 concerning a claim in the sense of originating process, a Part 7 claim or a Part 8 claim, in circumstances with all that provision is dealing with is a specific subset of that sort of claim. There is no reason why claim within the meaning of Rule 34.3 cannot be interpreted by this court, which of course is not bound by any of the authorities dealing with the equivalent provisions in the CPR, in a way that it permits an applicant such as Cron AI, where there has been no interim relief granted, where the relief being sought on its application is a final form of relief, to fall within that rule. I don't think I can really assist your lordship much further, your honour much further on that at the moment.
Okay, thank you.
If you bear with me just one moment, I just refresh my notes. I observed Your Honour's expression when I made my submission that this court is not obliged to follow the any of the but is not
Well, I'm
bound
not
by.
well, I just quibble about it because I don't think I'm obliged to follow the rulings of the English court, but it's, I think, part of the structure of the court to follow, or not to follow, but to take very heavy account of decisions by the courts in England in relation to rules which are very similar in drafting form and substance to the CPR.
Yes, no,
So in other words, it's not technically binding, but nonetheless is highly persuasive.
And I wouldn't dissent from that. In the circumstances that we're in, which are presented to Your Honour in this particular case, however, I would invite Your Honour insofar as it is necessary to deviate from the decision in auto. If Your Honour is not with me on how that authority is properly to be understood and applied. If it does involve a deviation from the English jurisprudence, that it would be justified in this jurisdiction. This jurisdiction is focused on the efficient and economic progress of claims. A notice of discontinuance in this case would protect respondents insofar as the cost consequences under Part 34 would automatically apply, and it would be consistent with the overriding objective in my submission to adopt an expansive interpretation of Rule 34.3 if necessary to ensure that applications of this sort can be discontinued. Unless I can assist Your Lordship, Your Honour, any further on that, I would propose to move on to perhaps more fruitful ground in terms of the permission to withdraw application.
Yes.
So I took Your Honour a few moments ago to the application notice, which set out the grounds upon which permission to withdraw is sought. Those are, as you've seen broadly, that there has been, following the instruction of Towers and Hamlin, the applicant, Cron AI, has taken the sensible view in my submission that its existing application notice and Mr. Chabra's first witness statement do not adequately or satisfactorily particularise the grounds upon which a defence can be mounted to the claim.
Yeah.
Excuse me. And if I perhaps could, to make good that point, take Your Honour to my page 6 of the bundle, which would be your page 14.
Yes.
And this is Mr. Chabra's first witness statement that was filed in support of the set-aside application. And if you could turn over the page, so to speak, or move down to paragraph 4, entitled Substantive Dispute. This is where, as currently set out, Cron AI particularises its grounds for saying it has a real prospect of successfully defending the claim.
Yeah.
And it is obvious to lawyers' eyes that is unsatisfactory in terms of detail and particularization. Without delving into any of the actual detail of Mr. Chabra's second witness statement, what can't be doubted is that second witness statement contains significantly more detail about the parties' background relationship, the circumstances in which this loan agreement was entered into, and how that gives rise to at least two defences and potentially a counterclaim, which would give rise to a set-off. I think that can be taken from that document without looking at its substantive contents. In my submission, it is unsurprising that it is in that reply witness statement that sort of detail and particularization has come out. It is obviously a result of Cron AI taking legal advice from specialist DIFC practitioners. And as set out in the application notice, it's Cron AI's position that it would be preferable both for the court and for AIL for the current application to be withdrawn, and then a fresh application with proper evidence put in, which AIL, whether through Mr. Algaith or through Mr. Braganza, can provide evidence in response. There would then obviously be evidence in reply in the usual way, and then the parties' positions are set out, and the court can properly assess the merits of the set-aside application with all the relevant material and facts. As to the relevant test that Your Honour has to apply or should apply on a withdrawal application, my learned friend and I are agreed that the test in the authority of parrot pay, the other decision of His Honour Judge Matthews, that I referred to earlier, that starts at my 554. So that would be your 562. Yep. And if I could ask Your Honour to scroll down to paragraph 8.
Yeah, well, I read these as well.
I'm grateful. Paragraph 10 is where the relevant test is identified by His Honour Judge Matthews, where he sets out that he would expect to see a change of circumstances, end quote, which, open quote, would justify withdrawal, end quote. In paragraph 20, subparagraph 1 of my learned friend's skeleton argument, he appears to suggest that, quote, a material, end quote, change of circumstances is needed to succeed on a withdrawal application. In my submission, the court should reject that additional gloss. It finds no support in parrot pay, which is the very authority, as I say, that both HFW and my learned friend have relied upon and has been relied upon throughout correspondence. In my submission, to impose a higher threshold of materiality would simply risk satellite disputes arising as to what actually counts as material, what that relevant threshold is, and whether any proven change in circumstances in fact meets that standard. In my submission, to impose that higher threshold would encourage respondents claimants to set aside applications, to force applicants to incur the unnecessary costs of pressing an application to a hearing, only for it to be dismissed, only to ask for it to be dismissed because there is a debate as to what materiality means. Therefore, the correct test, the test that this court should adopt in my submission is simply 1, has there been a change in circumstances? 2, does that change justify withdrawal? And 3, if they do, on what terms should withdrawal be permitted? In my submission,
can I just test this
yes,
change of circumstance approach? And hypothetically, an application is issued by a party. That party changes its mind about the application and wishes to withdraw the application. It issues an application to withdraw the application. The court is expected to say, well, has there been a change of circumstance? And I just wonder whether that is an appropriate way to proceed, because if permission to withdraw an application is refused, then the only consequence is that the application would then proceed to a hearing and be dismissed. So what's the significance of that?
In my submission,
in other words, what I'm wondering about is why I can see that there may be a subset of applications where permission is required. For example, if there's been an application for an injunction which has been granted or something of that nature. But in the vast majority of applications, if a party's made an application and then decided it doesn't want to move it, why are we taking up time worrying about whether there should be permission to withdraw, because the consequence of refusing permission is simply that it will be listed and dismissed because the party making it chooses not to support it.
Well, I mean, of course, one scenario is the one that faced His Honour Judge Matthews in Parrot Pay itself, which is where there's a dispute about costs. That obviously is one scenario. That ought not to be an issue here, given the position that Cron AI has taken.
Well, I understand there might be an issue as to cost, and that might justify a requirement for permission. What I'm slightly quibbling about is whether you have to show a change of circumstance before permission is granted, when the focus of attention is on things like costs.
In my submission, it's important. It is important in the circumstances currently before the court, because of course, what's not accepted by AIL is that if, for example, I'd appeared before Your Honour today and simply invited you to dismiss the application with cost consequences, AIL has not accepted that Cron AI should be entitled to properly formulate its application, or more adequately formulate its application, and issue a fresh application to set aside. If that had been agreed in correspondence in HFW's 2nd of June letter, then it may well have been that all that needed to happen today was that there should be just a consent order filed dismissing the application with costs to be assessed if not agreed, or something to that effect. But in circumstances where there's been a position actively taken that there will be an abusive process or vexation, if there was something to be an invitation to dismiss with costs, and that's been set out openly and explicitly in correspondence with the registry by HFW, it is important in these circumstances that permission is granted, that the court makes a determination that there has been a change of circumstance which justified withdrawal. It's important that a finding is made to that effect in these sort of circumstances.
Why in these sort of circumstances isn't the answer to apply, if necessary, to amend the application notice and/or to file additional evidence in support, with directions then being given to the respondent to the application concerning the filing of further evidence in response, or possibly linked with an adverse costs order?
That would have been an alternative route. The reason I should be careful not to say anything I shouldn't. That is an alternative route in the particular circumstance of this case, where the application, the witness statement is the original witness statement has. It's not just got gaps; it's got very, very large chasms where as litigators we would expect to see the reasons set out, and the view taken was that the better route was simply to start from a blank sheet of paper, so to speak.
Forgive me, but if there is a forensic point to be made concerning the chasms in the evidence originally filed, that forensic point is going to be available whether the application is amended and additional directions given for the filing of additional evidence, or whether the application is discontinued and a fresh application issued, surely. But it doesn't make any difference.
Yes, well, the point can be taken, but the difference is that if there's a properly formulated application from the beginning, the usual flow of evidence can take place, and Your Honour would have, or one of the other judges of the court would have the sort of usual application better, properly particularised, adequately particularised before it. There is no attempt here to dilly-dally at all. As I say, my client is prepared to undertake to file another application in short order. The aim has always been to ensure that both sides understand in properly formulated evidence what is in dispute between them. There is, if as becomes apparent from Mr. Chabra's second witness statement, a great deal of factual matters in dispute between the parties. And in my submission, the view taken it was that, as set out in the evidence and the application notice for withdrawal, is that the better way to deal with everything was, as I say, from a clean start. As Your Honour will see in the Part Pay decision, no, sorry, that's let me better phrase that. There are two alternative routes, but in my submission, you end up at the same outcome in my submission, because as I can come on to explain, that the vexing issue, the abusive process point, doesn't arise. So there's two routes, but before Your Honour today is a finding that there.
Yes, except that the amendment route rather eliminates the vexation issue, doesn't it?
Yes, but I would also have to satisfy Your Honour today that there was reasons for granting permit. Assuming let's say there was an application to amend before Your Honour, I would still have to satisfy Your Honour that there were good reasons for permitting an application to amend. And that would probably very much come back to the same question of whether there had been a change of circumstances. And I have no doubt that Mr. Marenbaum would be opposing that application on the circumstances, on the basis that there was no reason for there to be any amendments, and the application should just be considered today on the existing material. He would take all the same points, I have no doubt. So whatever route you get to, in my submission, the outcome would be a properly particularised application. In my submission, the application before you just achieves the same outcome through a different route.
Yes. All right. Well, I've flagged up a concern of mine. You've had an opportunity to address it.
You've heard my submission on that.
Yeah.
Turning then to the grounds upon which AIL opposes permission being granted today. The first and primary one is this vex twice abuse point. In my submission, there's nothing to that. The authority that was relied upon in correspondence by AIL, the decision in AES Middle East Insurance Broker Limited and GSB Capital. I don't think I need to take you to it, but the point being made by Justice Lemire in that case was that there might be an abusive process when there was an attempt to relitigate disputes in the DIFC in a claim where the same matters had been conclusively determined by the onshore Dubai courts. In this case, there would be no such vexation, because, of course, if permission to withdraw is granted, there will have been no determination of the issue. One goes back to square one, and there will be the ability for the parties to argue for the first time before Your Honour in due course the relevant legal merits of the application. There will be no attempt to relitigate anything that's already been decided, and that's what Justice Lemire was dealing with.
Yes, he was dealing with a different point. I see your submission on that. The point which I made at the outset, I think, remains the case, is that this application is not the place to be determining this vexation issue, is it? That issue only arises if you issue it as and when you issue a new application.
Yes, I'm only addressing the point because my learned friend takes it against me. My primary submission, as I articulated to Your Honour at the opening of my submissions in our discussions, is that, as you say, is an argument in response to a reformulated, refiled application, which is that the application should be dismissed as an abusive process at that stage. I don't think.
Since I might have to hear that application, I prefer not to express any views about it. But isn't the point being made a Henderson and Henderson type point, that you could have argued all the points you want to argue in the second application on the first application, therefore you should not be permitted, applying the Henderson and Henderson approach, to argue what could have been argued in the earlier application?
I'm not sure it's being put on Henderson.
Is that the point being made?
Well, I mean, I don't want to prejudge what Mr. Marenbaum might say, but I'm not sure that's how it's been put, because what's being said is that is that effectively the new application would be arguing the very same points that have been raised, whereas and Henderson and Henderson abuses where you had the opportunity to raise arguments, but you didn't before. You had the opportunity to raise causes of action, you didn't before. All in my submission.
Well, either way, it's either Henderson and Henderson, or it's an issue estoppel type situation. But in either event, it arises if and when you issue a second application, I think.
Yes, and I think in due course, once that was fleshed out, then obviously the Cron AI myself will be able to engage with it on the terms in which it's put at that stage. But I agree that Your Honour can't prejudge either your own decision on a subsequent application or the decision of any other judge on that issue. But as I say, it doesn't arise in any event because Justice Lemire was dealing with a different point. And then on the issue of delay, AIL complains that allowing withdrawal plus a fresh application will lead to, quote, a lengthy delay in enforcement. In my submission, for the reasons I've already articulated, that should be given very little weight in this case. AIL has not pursued its claim to recover this debt in a speedy manner. It has there have been a number of periods of time, many months, where no action has been taken. And as I say, it was only in January, late January this year, that any formal steps at enforcement where assets might be was taken. And in any event, any delay, actual or further delay, is of course compensated by the fact that the judgment carries a default judgment, carries a judgment interest under Article 9C of the Courts Law 2025. There is no suggestion by AIL that Cron AI would be any less good for the money in, say, 2 or 3 months' time. It can't make that submission because there's no evidence for it. So in my submission, if there is any delay, it will be adequately compensated for it. Those were my submissions, Your Honour, on the withdrawal application. I won't address what I would propose the terms of that withdrawal.
Well, let's leave the substance to one side for now. All right, thank you. Right, Mr. Maribond, can you confine your submissions for the purpose of this exercise to the 2 prior points? That is the status of the notice of discontinuance and the application for permission to withdraw, please.
Yes, my lord. I think I agree with Mr. Hogan, who's identified the point that whereas discontinuance is a unilateral act, and to challenge it, the challenge is brought post facto. For withdrawal, the court's permission is required, and if that permission's not granted, the court may well go on to determine the application. I rely for that position on the Parrot Pay case. To which your lordship has already been referred. In paragraph 11, His Honour Judge Matthews commented that he hadn't been asked to deal with the merits of the application, but if he were, he'd go on to decide whether it's appropriate to dismiss it on its merits, and that's because in his view there was no change of circumstances shown such as to justify its withdrawal. Your lordship, I think I'll go on to that and why there's no such change of circumstances in this case. But your lordship asked the prior question of why this all matters in a sense. Why can't the defendant be allowed to simply withdraw its application, pay the costs incurred to date, and then if it wishes, make a fresh application to set aside a judgment.
Or which is the same thing, amend its application, rely upon the evidence, reply as evidence in support, and give directions for you to file evidence in answer to that.
Well, my lord, the answer in short is the grave prejudice that's caused to the claimant and a judgment creditor, which has been kept out of its money for a very long time, and it is trying to enforce that judgment in England because the debtor is an English company, and that's I'm instructed that's where the assets are identified to be, and it's now left with a question mark over the status of that default judgment, making it difficult to go to an English go to an English court or a court abroad and straightforwardly to seek seek to force it when arguments might be raised as to its finality. That is a real prejudice, and it does have to be justified. If this were an application to amend, as your Honour suggested, applicants would have to grapple with the principles that apply to very late amendments, which threaten to derail a hearing date. And at least in the context of amendments to statements of case, it's well established that change of lawyers is not or is very rarely a good reason in that context, such as to justify a very late amendment that would threaten a hearing date in that way. And I rely for that proposition on the authority. It's not before the court because it was a point made by your lordship, but it's the authority of Qua and Goldman Sachs, paragraph 47, and the reference for that is 2015 England and Wales High Court 759 com, and that's Mrs. Justice Carr DBE. The fact that the amendments would be seen to be very late can be seen from when this evidence has been delivered, which was, as I think it's common ground, after close of business on Thursday before the hearing, therefore reaching us Friday morning. That's not enough time to deal with it, and it's if it were admitted, it would derail the hearing, and your lordship would have to be satisfied that that very late amendment was justified. In my submission, the court couldn't be satisfied of that on the established approach as set out.
Well,
in the authorities.
The court, if I may say so, the principles which apply to the amendment of pleadings where a trial is at risk are rather different to a situation where there's an application to amend a notice of application, where the relief sought is to set aside a judgment which would otherwise be final as against the party applying to set aside, which obviously has very significant consequences for that party. But anyway, what there is, despite my raising the issue, there is no application for permission to amend. So we need to put that to one side, I think. And the issues that arise are, one, is the notice of discontinuance valid? And your submission is it's not, essentially for the reasons that were explored with your opponent by me in his course of his submissions. And you say the application for permission to withdraw should be dismissed as well.
Yes, I do. I do, my lord. And I think what's relied on, it's the common ground that a change of circumstance is necessary. In my submission, it makes no sense to say that it doesn't need to be material. I mean, what material means is that it's relevant in the sense of justifying the withdrawal of the court to allow withdrawal.
Right, well, that's relevant to the withdrawal application. So, in relation to validity and effectiveness of the notice of discontinuance, do you wish to say anything other than the points which I explored with your opponent?
In brief, my lord, I suppose yes, I do. So that the sort of case that my learned friend, adding briefly, the case that my learned friend relied on, Galazzi and Christoforou, that was about whether there could be a partial discontinuance of a cause of action, but it was still concerned with the discontinuance of parts of a claim pleaded in the statement of case. That's not the same. The second point, other than those already canvassed, it's just I suppose the definition of claimant, again in Schedule 2 in the schedule to Part 2 of the RDC, a claimant is defined as a person who makes a claim, and claim is not a defined term. The third point, it's interesting. I mean, RDC 34.16 hasn't been referred to, but it's I think relevant in both contexts. The claimant who discontinues a claim needs the permission of the court to make another claim against the same defendant if he discontinued the claim after the claimant filed a defence. Well, I mean, one doesn't file a defence to a default, an application to set aside default judgment. So I suppose my learned friend would be inviting the court to read that as after the respondent filed evidence in response, but again, it's stretching further the words of the RDC, and that his other claim arises out of facts which are the same or substantially the same as those relating to the discontinued claim. So in any event, of course, if the notice of discontinuance were valid, the court's permission would be needed. But the very language of that provision, again, tells against RDC 34 being available in the context
All right.
of...
I don't think I need trouble you any further in relation to the notice of discontinuance point. So we're now at the withdrawal application.
Yes, my lord. So there is an express request or application to the court, which is at it's both in the letter to the registrar and in the final paragraph of my skeleton, paragraph 36. Respectfully invites the court to dismiss the application, alternatively to grant permission for its withdrawal only on terms that the defendant be debarred from issuing such further such application. The court certainly, in my submission, has power to impose such a condition, and it's appropriate and proportionate to do so. If the court is able to take a view today that it would be abusive for such an application to be pursued and would unduly and unfairly prejudice the claimant. The court, in my view, needs to start by considering the change of circumstances that's been alleged to justify withdrawal, and that is that sentence. First, it said that there's a suggestion first that the claimant has in some way delayed in making it in seeking to enforce the default judgment. I mean, there's absolutely nothing in that, and my learned friend put it two ways. First, he said that there was a long delay in obtaining judgment in the first place. But the reason for that, my lord, if your lordship looks at the bundle, is that there were repeated acknowledgements of the debt. If your lordship goes to page, I've got it as 124 of the bundle, adding 8, I suppose that would be 132 for your lordship? It should be a payment advice to Cron AI Limited.
Yes.
So that's the loan being advanced the 26th of June, and then on page 126 there's chasing emails to Mr. Chabra asking about when the loan's going to be repaid, and they're from Miss Twinkle Newcup in December 2024. And then at the bottom of page, what is for me 128, Mr. Chabra replies on the 1st of November, "Hello, Twinkle. Hope you're well. I have confirmation that AML didn't go through for opening an account. We restarted the process less than 12 hours ago. We're opening an independent bank account to avoid issues that we're facing currently. So no suggestion there's any dispute of the debt. Just saying, I'm sorry I haven't been able to pay yet. We've got a problem with our banking." And then this sequence carries on for a very long time. You can see before that, October the 31st, earlier in time, they were chasing. Tushar Chabra, "Hi Twinkle, apologies you haven't heard from me. I was down due to some health reasons. I joined work back on Friday. I'll share details with you later." That's asking for bank account. That's in reply to an email asking for bank account details. There's more excuses. Page 132, "Hello Twinkle, I was in flight. Let me get back to you today with an update." Page 139. "Dear Twinkle, as mentioned earlier to Mr. Mohammed, we're awaiting confirmation from Capital One Bank on the account activation. To reassure, we want to close this transaction as soon as possible to be able to close this transaction." That's the repayment. "We will let you know as soon as we hear from the bank." And this continues all the way to page 158. There's a further sort of acknowledgement of payment. This is back in August 2024, so soon after the debt was soon after the debt fell due, and he's been saying, "Hello Twinkle." So we're going backwards in time chronologically. "Hello Twinkle, I'm not sure what's going on." At the bottom of page 158, "As a test, I'm transferring a small amount again from the account today. The money is debited from my account. I've also shared the account screenshots. Please give me to the end of the day to resolve it." So there's been delay, the reason that there's some delay in seeking to obtain judgment is because there's been lots of requests for time to pay, implicit acknowledgements of the debt, and absolutely no suggestion whatsoever that the debt was disputed until much later. And indeed, even when Mr. Chabra, even once judgment is obtained, and Mr. Chabra writes to the registry, that's on page 9 of the bundle, exhibit TC1. He doesn't actually say that the debt is disputed. He just says that they haven't been properly served with the judgment. He says it's without prejudice, but again, there's no sort of attempt there to articulate any sort of defence, and no engagement. Now, as to why then after that the sort of enforcement attempt proper begin in England in January. I've already mentioned the fact that it's an English defendant company, and that's, as I understand it, where assets have been identified. But the parties were in without prejudice discussions between August 25 and January, December, January 2026. And the reference for that is Mr. Braganza's witness statement at paragraph 31, which is on page 15 for your honour's note of the bundle. So there's been absolutely no unjustified delay on the claimant's account in seeking to enforce. Now, as to then the behaviour of Mr. Chabra, it's really remarkable. He's delayed first between sending his email to the registry where he sort of acknowledges the default judgment and says he's opposed to enforcement. He doesn't actually say he's applied to set aside until he does apply to set aside, and then it's said by him that he's unrepresented and change of lawyers is significant. But if your lordship goes to page 66 for me of the bundle, I suppose for your lordship page 74, if your lordship's 8 pages ahead, it's a letter from Legal Vision dated the 25th of July 2025.
Yes.
To HFW. So Legal Vision were Cron's lawyers and the defendant's lawyers at this time. So this is after the default judgment has been entered. HFW have written to them saying, well, your client's subject to a default judgment. There are discussions with them about other matters. They say, we confirm that we act for Cron AI Limited, our client, solely in relation to the statutory demand dated 20th of May 2025. We have not been instructed to represent our client regarding the DIFC court judgment proceedings. Accordingly, any correspondence concerning the judgment should be directed to our client personally. This letter serves as confirmation of the scope of our representation. So he's intentionally unrepresented in relation only to this application. He's playing games, Your Honour, and that can also be seen from the stage when he actually makes the application to set aside, and that's at my page 83. It's perhaps Your Honour's page 91. This is an email from Mr. Chabra dated the 23rd of April 2026 to HFW, to Emily Hook and Nick Braganza of HFW. This is where he serves the application. I mean, note there, 27th of March. So he's only he's serving the application seemingly almost a month after it was made. But that in itself is an unusual delay. But he says and he says that he intends to file a supplemental witness statement, which will be served within 2 weeks. Well, that didn't happen. But he's copied Karishma Vora, who's an English barrister, and Tulsi Bhatia, who is an associate at Cook, Young and Keedon LLP, who are representing him in the English enforcement proceedings, or representing Cron in the English enforcement proceedings that were at that stage underway to enforce the default judgment over here. So it's perfectly clear that defendants shouldn't be afforded any sort of leniency on the basis that it was technically unrepresented in the scope of this particular application when it made its application to set aside default judgment, because it was perfectly capable of instructing very high-powered legal teams, but in multiple continents at a similar time. So I'm not saying, my lord, I'm not saying, Your Honour, that the instruction of new lawyers can never be a change of circumstances that justifies the withdrawal of an application. But I think I am saying that it's in this case it clearly isn't. That I'd add to that point by asking the court to consider all the circumstances that are at play here, and I think that appears particularly from paragraph 30 and following of Mr. Braganza's statement, which is at my page 14, so perhaps Your Honour's page 22 of the bundle. So he's pointed out that there's 30A, he explains the corresponds with legal vision. And what happens then is at paragraph 32, it's explained that the exhibit wasn't even served at the time that the witness statement was served, and the claimant only found out about it because but later from the registry, later from later on. The English enforcement proceedings are dealt with it at paragraph 37. That's which is on the following page. There's a circumstance in which evidence in response there in that application too was filed, was not filed, and then it was only late that there was an application, essentially a request for a stay. In the context of this application that's now before the court, obviously the defendants had two applications for an extension of time to file its reply evidence. First, from the 14th to the 21st of May. Second, from the 21st to the 25th of May. Then an hour before the deadline for filing on the 25th of May, or about an hour, and incidentally, that is on the eve of a public holiday in the UAE, which went from Tuesday to Friday of that week. It then changes course and says that it intends to withdraw the application. And again, there's no suggestion then, for example, that it intended to file reply evidence. And indeed, the reply evidence was the intention to file it was kept up their sleeve until even when the skeleton argument was filed late on the 17th. This is I'd submit to the court this application to withdraw. It comes in the context of a wider context of a casual attitude to it, and a disregard for the defendant's obligations to the court and as a litigant, both when it was, as it were, unrepresented in these proceedings, but had legal representation for other purposes, and also after it's regrettably after it's been represented, and the court ought to take that into account. That be to permit this application to, as it were, to proceed to grant it would essentially be handing a mandate to the defendant for further procedural gameplay and casual attitudes to compliance, in addition to what it's already undertaken. The defendant now says that the defendant says in its skeleton argument that there is enough on its existing evidence to determine the set-aside application. It says in its favour. That's paragraph that's paragraph 37 of my learned friend's skeleton argument. He says that the court is still able to, he says that although there's additional flesh that needs to be put on the bones of the first witness statement of Mrs. Chhabra, the court is still able to find that Cron AI has a realistic prospect of success in defending the claim and that its defence is not fanciful. So he says that it's enough. In those circumstances, the court shouldn't permit the withdrawal of this application. It would cause prejudice that's to the claimant for no real or good justification. And it should determine the application on the evidence that's currently before the court, and that, in my submission, should not include the very late filed reply witness statement.
If I was minded, and this is hypothetical at the moment, if I was minded to grant the application for permission to withdraw, then I could impose conditions, I think, as follows. One, require dealing with the question of costs. Secondly, I could impose conditions that required any further application to be issued by no later than a fixed forward date, together with the evidence. And I could express that to be without prejudice to your right to apply for the dismissal of the application on the basis that of the vexation point that you rely on, and without prejudice to the defendant's answers to that. So in other words, to leave that point live. And if the directions were sufficiently tight and if they were made on unless terms, wouldn't that protect you?
My lord, I think if they're made on less terms, both in relation to costs and those other directions, I suspect that would give more of a measure of protection as to the as to the position. I probably need to take instructions.
So what if I went down that route? What would be your preferred timings?
My lord, I suspect that those instructions will be very keen and the claim need to get on with it as soon as possible.
7 days for the application and the evidence in support.
I don't, my lord. May I'm sorry. I know that your lord's being generous with my lord's being generous with this time. May I just? Would it be possible for me just to take instructions very briefly via WhatsApp?
Of course.
Thank you.
Of course. Of course.
Just turn my camera. So my lord, the only concern that those instructing me have as to 7 days is that if there's to be a debarring provision as to the costs, I suppose it would be an unusual order for the cost to be ordered to be paid within just 7 days, as opposed to 14. If the courts for sentences that cost.
Okay, you give me the timings that you suggest are appropriate then.
So 14 days for their application and cost to be paid at the filing of at the date of the application. So cost to be paid within. Sorry, my lord, I'm being given different instructions. Sorry, they want 7. My lord, I'm so sorry. Please give me. Please bear with me for what One moment. So, my lord, I think the preferred order is 7 days, both for the costs and for the payment of costs and for the making of the application. Then
you're right about the costs. Put the cost to one side for the moment. So 7 days to issue any renewed application. I'll come back to costs. We'll deal with that separately.
Yes, my lord. Those are my.
So your submission is that if I were to accede to the submission giving permission to withdraw, it should be strictly on terms. A, as to costs, which we'll come to. B, any fresh application to be issued no later than 4 p.m. 7 days from today.
Yes, my lord.
Together with the evidence in support. And in default, judgment to be entered, the judgment stand.
Yes, my lord.
With no further application to be permitted. B, evidence in answer, assuming that they filed the application.
So 14 days after that. So in other words, 21 days from today.
Yeah. C, evidence in reply.
7 days after that, Your Honour.
Yeah. And then list first available date.
Yes, Your Honour. And I think preferably it might be sensible for a preference to be expressed if it can be for the case to be heard by the hearing to be heard by Your Honour.
Yeah. I think that would probably happen anyway. All right, that's very helpful. And then, so far as costs are concerned, you say I should impose a condition that the defendant pay the costs of an occasion by the application for permission to withdraw.
Yes. Costs. I think all of the defendant should pay the costs. At least of an occasion by the application to withdraw. I mean, we'd be asking the court for a summary assessment today and for payment within 14 days. I mean, there is Your Honour might take the view that if Your Honour took the view that but for that on the papers today, as it were, that on Mr. Chambers' first statement and not his second statement, if the court would otherwise, on the basis of that, have simply dismissed the set aside application, but for that, I mean, the court might take the view that all the costs incurred up to and including today are costs that should be borne by the defendant.
I think that would be excessive. On what basis are you asking for the cost to be assessed?
I think let me just I'm sorry, my lord, let me take instructions. My lord, we do on this occasion seek indemnity costs. There's a number of factors relied on as taking this case out of the norm. The repeated delays.
All right. Well, we'll come to that in a moment, but I understand the point. All right. Is there anything else you want to say on the substance before I now hear submissions in reply, give a judgment, and then we'll see where we are after that?
I'll just double check, Your Honour.
Yeah.
Yes, there's an application that the court could impose a condition that the default judgment sum should actually be paid into court, pending the resolution of the application to set aside a fresh application.
Yeah, that engages potentially difficulties, doesn't it, given that there's been problems in relation to enforcement, because there might then be a stifling argument, which I can't resolve today, because you haven't made that point before.
Yes, Your Honour.
So I don't think that gets up and runs, I'm afraid. If you wanted to make that point, you'd have to make it earlier so that they'd had an opportunity to deal with the stifling point. All right,
Yes,
thank you very much. Thank you. Right, Mr. Hogan, reply.
Yes, very briefly. I think the main point of dispute is in relation to delay or there not being a delay. In relation to my learned friend's submissions, that there was these various repeated acknowledgements, and that's why of the debt, as he puts it, and that's why there were no steps taken between August and December 2024 to progress matters. Well, in my submission, if you actually read the correspondence and you read what Mr. Braganza says about it, effectively the complaint is made that there was radio silence from Cron AI from the end of October 2024. So in that sense, it's not as if there was sort of ongoing engagement in that period. In relation to apparent delay by my client in making its application, well, a point's made by my learned friend. Well, between September 2025 and December 2025, there was attempts at settlement, and there was lots of ongoing discussions. Well, that cuts both ways, insofar as that is a justifiable explanation for why no enforcement action was taken in that period. It's equally an explanation for why there was no attempts to set aside the default judgment in that period. That period is, in my submission, neutral. In relation to the point about Cron AI having other lawyers in different jurisdictions, you've seen references to Legal Vision and also to CYK. In my submission, none of those sets of solicitors are DIFC specialists. Your Honour, there is a much broader background.
To be fair, I don't think that was the point that was being made. The point that was being made is if you can instruct eminent English solicitors to conduct one aspect of the legal relationship between the parties, if and to the extent you need specialist DIFC solicitors to conduct another aspect, then you can and could have instructed them.
I accept that point. The difficulty, again, the issue for my learned friend is, of course, is that he prays and aids the period of settlement discussions between September and December 2025. So when you've already got eminent legal solicitors on board who are assisting Cron AI with the settlement discussions, it would have made little sense, and would have been wasteful of costs in that period to have instructed DIFC lawyers. And so if there's been any delay in instructing DIFC lawyers, it's a very short period from between the end of January, when the English proceedings were commenced, and the start of March this year, when the application to set aside was issued. And then in relation to this point that were you to grant permission to withdraw, you would be risking giving a, quote, mandate for casual compliance with the court rules. Well, the usual way to deal with that, of course, is in cost orders. In relation to the proposal that you were discussing with my learned friends, I can confirm that my client is willing to agree to an unless order for filing any renewed application within 7 days, and to filing its reply evidence within 7 days of receiving the responsive evidence from AIL. Obviously, there's discussions to be had about costs in relation to how they should be assessed and in what amount, but I take Your Honour's indication that you'll leave that over until after you've given your judgment.
Will. All right. Anything else you would wish to say?
Unless I can assist Your Honour any further, those are my submissions.
I'm very grateful. Thank you very much. This is the hearing of, in theory at least, 3 applications. Firstly, an application by the defendant, in effect for a declaration that a notice of discontinuance it filed in relation to an application to set aside judgment be declared valid and effective. Secondly, if and to the extent that is to be refused, there is an application by the defendant for permission to withdraw its current application to set aside the default judgment obtained by the claimant. Thirdly, and in theory at least, there is the set-aside application itself, which would remain to be determined in the event that the validity and effectiveness of the notice of discontinuance declaration application failed and the withdrawal application failed. I've come to the conclusion that the application for a declaration concerning the validity and effectiveness of the notice of discontinuance should be refused, that the withdrawal application should succeed but on terms, and that therefore it is unnecessary for me to determine the set-aside application today. My reasons for reaching that conclusion, in summary, are as follows. It's necessary to start with a brief factual background in relation to the dispute between the parties. Procedurally, the position is that that on the 14th of May 2025, a default judgment was entered against the defendant in the sum of $217,059 United States dollars and 32 cents plus interest. On the 19th of September 2025, the claimant issued its application to enforce the default judgment by separate enforcement proceedings, and on the 24th of September 2025, this court, by its enforcement judge, declared the default judgment to be final and executory, pursuant to Part 45 of the rules of the DIFC courts, the RDC, which is, as both parties accepted, the first step to seeking to enforce the relevant judgment. I think some proceedings were commenced in England to enforce the judgment, but those have gone so far not very far beyond the issue of those proceedings, if any further at all. No steps have been taken in Dubai to enforce the relevant judgment. There is on the 27th of March 2026, the defendant issued its set-aside application, and the set-aside application, which of course was issued originally in the enforcement proceedings, I think, was transferred to this claim. What then happened was that there was, first of all, a series of applications for an extension of time in which to file evidence by the defendant, and then the service of what purported to be a notice of discontinuance. The set-aside application was served on the claimant's legal representatives on the 24th of April. On the 7th of May 2026, evidence in response to the set-aside application was filed, and thereafter applications were made for an extension of time in which to file additional file evidence in reply. It would appear that on the 6th of May 2026, the defendant approached its current solicitors, Trower & Hamlins LLP, for the purposes of asking Trower & Hamlins to act in these proceedings on its behalf. There was an attempt to agree extensions of time for the filing of evidence. Those came to nothing, and on the 8th of May, Trower's filed a Part 37 notice of change. The extensions of time came in the following circumstances. Evidence in reply was initially due on the 14th of May. On the 12th of May, Trower's sought the claimant's solicitor's agreement for an extension of time. That was refused the same day by the claimant's solicitors. and on the 14th of May, an application for an extension of time to file the reply evidence to the 21st of May was made. Following a further extension of time application on the 21st of May, the parties were able to agree on the 22nd of May an extension until the 25th. And but on the 25th of May, Trowers wrote to Holman Fenwick, the solicitors acting for the claimant, inviting Holmans to consent to the withdrawal of the set-aside application on the basis that the defendant would pay the claimant's reasonable costs of an occasion by the set-aside application, and on the basis that the defendant would then file a fresh application, further and better articulating its grounds for seeking the set-aside of the judgment. That was not didn't receive any response, largely I think because it was the Eid holidays at the time, and that caused the defendant to issue its notice of discontinuance, or what purported to be its notice of discontinuance, on the 2nd of June 2026. The notice of discontinuance was in standard form. It was issued, as I say, on the 2nd of June 2026, under the heading, quotes, details, close quotes. The first question that was asked was, quotes, are the defendant discontinuing part of the claim, close quotes, to which the answer given was yes. And then the notice went on to say that this was a notice that related to the defendant's application of the 27th of March 2026 to set aside the default judgment of the 14th of May 2025, and concluded, quotes, the defendant wishes to discontinue this application, close quotes. It was then the form then asked for confirmation that the discontinuance falls under the provision of the rules, to which the answer given was yes. And further, the form asked whether it was the position that permission was not required, to which the answer given was yes. That was met by correspondence from the from Holmans, the solicitors acting for the claimant, maintaining that it was wrong in principle to seek to discontinue an interim application or an interlocutory application by service of a notice of discontinuance. That issue initially came before me on paper. I concluded that inevitably on a preliminary basis, that the notice was invalid because it did not apply to a claim or part of a claim, but nonetheless directed that this hearing take place, at which, amongst other things, the validity of the notice of discontinuance could be finally determined. Against the possibility that I should conclude that the notice of discontinuance was invalid, on the 16th of June 2026, the defendant issued an application, as I said, for an order that it be granted permission to withdraw the set-aside application issued on the 27th of March and for consequential directions. That then, in essence, is the procedural position. The first issue that arises, therefore, concerns whether the notice of discontinuance was effective and should be declared as effective for the purpose of enabling the defendant to withdraw its application to set aside. Notices of discontinuance are governed by RDC Part 34, the relevant core provision of which is Rule 34.3, which provides, quotes, a claimant may discontinue all or part of a claim at any time, close quotes. Other provisions within Part 34 are relevant because of the dispute between the parties as to whether or not notice of discontinuance can be served in relation to an interlocutory application as opposed to a claim or part. RDC 34.4 continues continues from RDC 34.3 as follows, quotes, however, 1. A claimant must obtain the permission of the court if he wishes to discontinue all or part of a claim in relation to which A, the court has granted an interim injunction, or B, any party has given an undertaking to the court. 2, where the claimant has received an interim payment in relation to the claim, he may discontinue the claim only if A, the defendant who makes the interim payment consents in writing, or B, the court gives permission. 3, where there is more than one claimant, a claimant must not discontinue unless A, every other claimant consents in writing, or B, the court gives permission, close quotes. The procedure for discontinuing is then set out at Rule 34.6 and following. The liability for costs that follows is dealt with at CPR Rule 34, at RDC 34.15 and following, with RDC 34.12 providing that discontinuance against any defendant takes effect on the date when the notice of discontinuance is served. By RDC 34.16, quotes, a claimant who discontinues a claim needs the permission of the court to make another claim against the same defendant if 1, he discontinued the claim after the defendant had filed a defence, and 2, the other claim arises out of facts which are the same or substantially the same as those relating to the discontinued claim. The point which is relied upon by the defendant, and which I accept, is that Part 34 is limited in its terms to the discontinuance of a claim or part of a claim contained in originating process issued by the court under either Part 7 or Part 8, or conceivably a counterclaim filed in proceedings commenced by a Part 7 or Part 8 claim form. This analysis is the correct analysis, is supported by English authority in relation to rules which were or are in identically the same terms as the relevant RDC rules. The relevant authority for present purposes is the decision of His Honour Judge Paul Matthews, sitting as a judge at the High Court in Inner Mongolia Happy Lamb Catering Management Company, in Otto and others against Inner Mongolia Happy Lamb Catering Management Company and others, 2023 EWHC 2920 Chancery, 2024 Costs LR 57. The principle to be derived from that authority is that the decision to withdraw an interim injunction application was not a discontinuance under the equivalent civil procedure rules to Part 34 of the RDC. Because an interim injunction was not part of the final relief sought in the claim, because whilst an interim injunction was not part of the final relief sought in the claim, it did not follow that it amounted to a separate claim under the rule. The judge held that a claim under CPR Part 38 was whatever was the subject of the claim form or other originating process. Here, that is the principle to be derived from that case. The relevant rule in the civil procedure rules, which was at Rule 38.1, is in identical terms to the rule set out in RDC 34.1, and the principle which I've attempted to summarise is set out in paragraph 15 of the judge's judgment. In my judgment, it is entirely clear that the judge's analysis is a correct one, and one which I should give effect to. As I've already indicated, the relevant rule is one which refers exclusively to a claim, whilst it is true to say that the word claim is not a defined term within the RDC any more, I think, than it is within the CPR. The relevant rule must be read in its correct procedural context. It must also be read in the context of Part 34 as a whole. In those circumstances, the service of the notice of discontinuance was one which was ineffective in the circumstances, because, first of all, the defendant is not a claimant, and the application was not a claim in the sense identified in the authorities to which I've referred. That a claim was meant to mean what it was held to mean in Otto is apparent from the terms of Rule RDC 34.4, all of which it can only be of any relevance in the context of the discontinuance of a claim or part of a claim contained in originating process. And for what it is worth, that exactly similar principles apply when RDC 34.16 is read as well. In those circumstances, I have no hesitation in concluding that the notice of discontinuance was not effective as a withdrawal, and therefore, if the application is to be withdrawn at all, it must be by one of three methods. Either it must be withdrawn by consent, or it must be dealt with by way of an application to amend, or third, there must be an application, or it could be dismissed on its merits. The route which the defendant has chosen to adopt is to make an application for permission to withdraw the application. This has been resisted on a number of different grounds. The resistance includes the suggestion that any subsequent application to set aside the judgment would be one which would be regarded as vexatious, and therefore not one which the court should permit. As I made clear to both counsel, whether it was to be submitted that a second application should fail, either on the basis of some form of estoppel or on the basis of a principle in Henderson and Henderson or some allied principle, is not an issue that can possibly be considered in the context of this application. That issue arises, if it arises at all, only if and when the defendant issues an application to set aside the judgment subsequent to being given permission to withdraw its present application. The second point, the subsequent points which are made in relation to the application to withdraw, is that the application shouldn't be permitted save and except if that where it's demonstrated there have been a material change of circumstance, and in any event the court should exercise its discretion by refusing permission to withdraw the application because it has not been demonstrated, because to permit the withdrawal of an application in circumstances where there is a threat by the withdrawing party to issue a similar application, it is a recipe for wasting time and allowing costs to incur needlessly. The principle which applies, or which I'm invited to apply, when deciding whether or not to give permission to the defendant to withdraw the application, are those said to be contained in the decision of His Honour Judge Paul Matthews in Parrot Pay Limited in liquidation against Goddington Pierce Limited in provisional liquidation, 2023 EWHC 2774 Chancery. The remarks of the judge in that case were in the context of what was to have been a contested application between the parties for an application to discharge the appointment of provisional liquidators to Goddington Pierce, and to strike out a winding up petition which had been presented against it. The issue that arose concerned whether or not permission should be given for the withdrawal of the discharge application and for the consent and for consent to be given to a winding up petition in relation to Goddington Pierce. The relevant points for present purposes are contained in paragraphs 8 to 10 of the judgment. Insofar as is material, the judge said the following, quotes, there is a small point about the jurisdiction of the court to permit the withdrawal of an application as opposed to its dismissal when the applicant does not pursue the application. There is no express power that I'm aware of, or indeed that counsel is aware of, permitting an application once made by issuing the application notice to be withdrawn. 9. However, CPR Rule 3.12M does allow the court to take any step or make any order for the purpose of managing the case and furthering the overriding objective. I have on at least one previous occasion, held that this power extends to permitting amendments to be made to applications once issued. I can see no reason why the width of those words should not extend to permitting an application to be withdrawn instead of simply amended. So I hold that it is possible. Of course, any permission given by the court to withdraw an application will be on such terms as the court might consider appropriate, including costs or other consequential matters. 10. In this case, I note that the decision to withdraw the discharge application was made a long time before, after it was originally issued, I think some 16 months. And there have been a number, I think 11, witness statements already filed and about half a dozen expert reports filed in relation to this matter. Certainly a lot of preparation has been done. There does not appear to have been any change of circumstances which, on the face of it, would justify withdrawal at this stage, save simply a change of mind on the part of the applicants for discharge. I note in passing that Parrot Pay, by its liquidators, alleged serious breaches of the provisional liquidation order on the part of the directors of Goddington Pierce, but I do not need to deal with that. So I consider, first of all, the discharge application. As I say, Goddington Pierce's directors now seek to withdraw it. Certainly they are not here to pursue it. I have held that the court can permit a party to withdraw an application. In this case, Parrot Pay agrees, but of course wants to make sure it's awarded its costs. I was not asked to deal with the merits of the application, in which case I would go on and decide whether it was appropriate to dismiss it on its merits. I will therefore permit the withdrawal of the application, but on the basis that the costs need to be dealt with. I can see no reason why the general rule should not apply, and that therefore the successful party here, the liquidators, should pay the costs paid by the unsuccessful, that is, in this case, Goddington Pierce, close quotes. In the circumstances of this case, therefore, it is submitted that before an application to withdraw can be permitted, there must be demonstrated to be a material change of circumstance. In my judgment, that goes much further than the judge did in Parrot Pay, and I reject that as an analysis. Indeed, I would go further. I'm not satisfied that in all cases, at least, it should be necessary for a party seeking permission to apply to withdraw an application it itself has issued but no longer wishes to proceed with, to show a change of circumstance before it is permitted to withdraw an application. The point to be there will be applications where it may be inappropriate to permit the withdrawal of an application, or not to permit it without a change of circumstance. But in most interlocutory applications, if a party has issued an application but has had a change of mind, then subject to the payment of costs and any other procedural directions that are appropriate, there's no reason why that party should not be permitted to withdraw the application it itself has issued. The reason why permission is required is very largely to cater for the cost consequences that follow from withdrawal. If withdrawal were permitted without permission having to be sought, then no provision will be made in relation to the costs, very often after substantial costs have been incurred, which would plainly be wrong. In those circumstances, as it seems to me, if the defendant in this case wishes to withdraw its application to set aside the judgment that has been entered against it, it is not for the court to stand in its way, subject to the giving of appropriate directions. As the judge noted in Parrot Pay, an alternative is for an application to be made for permission to amend an existing application, but that is not an application which has been made in the circumstances of this case. Therefore, I conclude that in principle, I ought to permit the defendant to withdraw the application. However, it is idle to ignore, for present purposes, entirely the fact that the defendant has indicated an intention to issue a further application. The underlying reasons for this are essentially as follows. The application to set aside was issued in circumstances where the defendant was acting by its directors and was not legally advised in relation to the application, although the evidence suggests that they were being legally advised in relation to other aspects of the relationship between the claimant and the defendant. In consequence, the application and the evidence which has been filed in support of it is unsatisfactory, to put it in neutral terms, and the evidence which the defendant has been advised to rely upon is set out in the third statement of the second statement of Mr. Chabra filed in these proceedings as a reply statement to the original application. That was filed very late. There was no sensible opportunity for the claimants to respond to it, and therefore I have not referred to it in any detail other than to note that it contains the evidence which the defendant apparently would wish to rely upon in any further application to set aside. Although it was submitted that I should debar the defendant from issuing any subsequent application at all, in my judgment, that would be an excessive exercise of jurisdiction and/or discretion. It is not any part of the court's duty to prevent a party from issuing any application it chooses to issue. if the position is, as was submitted by the claimant, that any such application was bound to be met as a matter of law with a claim that it was vexatious or abusive, then the time to deal with that is if and when any such application is issued. Very sensibly, therefore, Mr. Marabram, on behalf of the claimant, having taken instructions, indicated the conditions which, in principle, his client would expect to be imposed as a condition of the defendant being permitted to withdraw the application. They were firstly that any application for any application to set aside the default judgment be issued by no later than 4 p.m. Gulf Standard Time, 7 days from today, and in default, the defendant be debarred from issuing any further application. My understanding from the submissions made on behalf of the defendant is that that was considered to be appropriate. Secondly, if an application is issued, then any evidence in answer was to be filed 14 days thereafter, and any evidence in reply 7 days thereafter, with the application to be listed for determination on the first available date thereafter. I'm satisfied those are appropriate conditions to impose. It is very important that if there is to be a further application, then leaving to one side the legal and factual merits of that application, that it be got on with in the interest of ensuring that within as sensible a time frame as can be achieved, the claimant knows the position it is in, so that it can either take steps to enforce or focus on resolving this litigation on its merits. 7 days is appropriate, in my judgment, because of the time that has been allowed to elapse since which I've attempted to describe in outline at an earlier stage in this judgment. What is required now is, if the defendant is to issue a further application, both the application and the evidence relied on in support of it is to be issued and served within the issued or filed at the register within 7 days of today, and in default, as I've said, the defendant will be debarred from further applying to set aside judgment. The only issue that remains concerns costs. It is not, as I understand it, objected to by the defendant that there should be a condition of being given permission to withdraw the application, that the costs often occasioned by the application must be paid by the defendant. There is a dispute between the parties as to whether or not that should be on the indemnity or the standard basis, which I will resolve following the delivery of this judgment. In principle, however, I accept the submission made on behalf of the claimant that any permission to withdraw must be made conditional on an order that the defendant pay the costs of an occasion by the application it is withdrawing. There was an application by the claimant for an order for a further condition, namely that the defendant be required to pay the whole of the sum claimed into court. The difficulty about that application is that the first time it was mentioned was in oral submissions. That does not give the defendant a fair opportunity to respond to it. It is well established on the case law that orders of that sort can only be made where the making of such an order will not stifle the application being made. And in the absence of any indication that an order in those terms was going to be sought by the claimant, plainly, no evidence has been filed by the defendant which addresses that issue. In those circumstances, I make no order in relation to that application. If there is to be an application requiring money to be paid into court, that would have to be dealt with separately. But I know of no procedural route that would permit that course. In the result, therefore, I refuse a declaration as to the effectiveness of the notice of discontinuance. I allow the application for permission to set aside the current application to set aside the default judgment the claimant has obtained, but strictly in accordance with the conditions that I've indicated. Right, costs.
Yes, Your Honour, I suppose the claimant, therefore, I think it's accepted in principle the claimant should get its costs. I briefly on the indemnity basis, I think the factors that take this case outside the norm have probably already been identified by me in relation to conduct. The very long delays.
Well, I suppose you're entitled to say, aren't you, that if you issue an application, allow parties to respond to it substantively, then decide to withdraw it because it's not in a satisfactory state, that is of itself conduct beyond the norm.
Yes, Your Honour, exactly.
Yeah, all right. Mr. Hogan, response to
that? In my submission, that there has been no conduct outside the norm. The test, as it's set out in the DIFC court's practice, it's paragraph 38.17.2, is that the conduct has to be unreasonable to a high degree. In NS Investments 2020 DIFC CFI 055, the Deputy Chief Justice said that the bar for indemnity cost was exceptionally high in the DIFC. In my submission, there is no basis for granting indemnity costs in the circumstance of this case in particular, where an offer was made at the end of May for the set aside application to be withdrawn on the basis that the reasonable costs of the claimant would be paid. That is essentially exactly what Your Honour has ordered today, and we could have avoided this whole situation had that simply been agreed to. So in those circumstances, at least from that stage, the conduct of the claimant, the defendant, has been entirely reasonable and proper, and there should be no order for indemnity costs in those circumstances.
Yeah, thank you. Reply?
Well, Lord, I don't accept if it's admitted that the test for indemnity costs is higher in the DIFC than is particularly higher in the DFC than, for example, in England. That doesn't represent the law, my understanding.
No, but what about the point that you could, if you had been acting reasonably, you would have accepted the proposal made back in May, allowing the withdrawal of the application?
It wasn't. It was only offered on terms as to the payment of our costs. It wasn't offered with the conditions that the court's now decided to impose. And it was offered on the express basis that a fresh application would be issued.
The issue I now have to determine concerns the costs that must be paid by the defendant as the price of being permitted to withdraw its application to set aside the default judgment the claimant has obtained. The claimant submits that the cost should be awarded throughout on the indemnity basis. It submits that the test for costs on the indemnity to be awarded on the indemnity basis in the DIFC courts is essentially the same as that in the courts of England and Wales, and that applying that test or those tests in the circumstances of this case costs should be awarded on the indemnity basis, because first of all, the defendant issued an application, then permitted the defendant to take steps permitted the claimant to take steps in relation to that application, before ultimately seeking to withdraw the application on the express basis that the application in the form it was in, couldn't succeed, and therefore a fresh application would have to be made. The response from the defendant is that there was no conduct outside the norm, or in any event, there was no such conduct from the time it offered to the defendant, or proposed to the defendant in May, that it should be permitted to withdraw on terms that it pay the costs. The circumstance it's necessary to start by identifying the appropriate test that must be applied before awarding costs on the indemnity basis. That test is in the DIFC courts essentially the same as that which has been applied in the English courts, and requires a party seeking costs on the indemnity to be assessed on the indemnity basis to establish conduct by the paying party that was outside the norm to be expected in the conduct of civil or commercial litigation, or in other words, conduct which is unreasonable to a high degree in relation to the conduct of the litigation. The essential point available to the claimant is that to issue an application to set aside judgment, to permit the claimant then to file substantive evidence in answer to the application at significant cost, and then having applied for 2 extensions of time in which to provide evidence in reply, not to provide evidence in reply, but instead to purport to serve a non-compliant notice of discontinuance is to be viewed as conduct that was unreasonable to a high degree, being conduct which would generate cost entirely unnecessarily. As I say, the response of the defendant to that is that an offer was made to discontinue paying the costs of the claimant, and that should have been accepted, and therefore its conduct thereafter could not be regarded unreasonable. I'm satisfied in the circumstances of this case that costs ought to be assessed on the indemnity basis, and my reasons for reaching that conclusion are as follows. First of all, as I've said earlier in the substantive judgment, this was a defendant who was represented by very substantial firms of solicitors in relation to other aspects of the ongoing debate or dispute between it and the claimant. There is no obvious reason, therefore, why an application should be made to the DIFC courts to set aside a judgment when that party was acting in person, when that party perfectly plainly could have instructed solicitors at a much earlier stage. Secondly, it is conduct beyond the norm, or conduct which is unreasonable to a high degree, to issue an application which is so defective that ultimately it has to be withdrawn because it cannot succeed. Whilst it is true to say that the defendant company was acting in person at the time the application was issued, there is no rule of either the DIFC courts or, for that matter, the English courts, that the rules do not apply to a litigant in person as they apply to a represented party. Therefore, to issue an application which is so defective it must be withdrawn is conduct that is unreasonable to a high degree. Thirdly, it is wrong to permit such an application to continue with costs being incurred by the respondent to that application as happened in the circumstances of this case. It is also conduct that is unreasonable to a high degree. Then to attempt to discontinue the proceedings by serving a notice of discontinuance in circumstances where, on the rules, for the reasons I've explained, such a notice of discontinuance could plainly not be effective in relation to an interlocutory application, and where, if it was to be effective, it would mean that it would a party to an interlocutory application could withdraw it without any consequences being imposed, which is a self-evident reason why that procedure is not available in the same way. So the question which then arises is this. This was an application which shouldn't have been issued in the form it was issued, and having been issued in the form it was issued, could have been and should have been withdrawn much earlier, but wasn't. And in those circumstances, as it seems to me, this is precisely the sort of case where costs should be awarded on the indemnity basis, because quite simply, this was an application which was issued in a form it should never have been issued in, and has been withdrawn on that basis. It is not sufficient, having issued an application in those that is defective in that way, then to suggest that it is open to the party who has issued the application simply to withdraw it, or ask for the agreement of the other party to withdraw it, paying costs on a standard basis without any other directions being put in place. In those circumstances, I conclude that the costs ought to be assessed on the indemnity basis. Right, next point. I'm taking it you want me to assess these costs on an immediate basis, is that right?
Yes, Your Honour.
Let me just make sure I've got the right cost schedule in front of me. This is your, I'm just scrolling down. This is the grand total of 45,831.54 US dollars, I think. Is that right?
Yes, Your Honour.
Very good. So what I would normally do if carrying out an immediate assessment would be to ask the paying party to go first, and then you can respond to any of the objections that are taken. All right, Mr. Hogan, what would you like to say in relation to the immediate assessment of these costs?
In my submission, my overarching submission is this is a matter which seems to have had a very heavy amount of partner time. Miss Saxena, who's the senior associate, appears to have had really very little involvement at all, despite having 8 years experience. For example, Mr. Braganza's attendance on unspecified individuals of 4 hours and 18 minutes. There's no reason why Miss Saxena could not have been responsible for those sorts of attendances. Similarly, attendance on others, there's no reason for a partner, when there's a senior associate of such significant experience, to be spending many hours on the phone and emailing others. In relation to the work done on the documents, Miss Hook's 26 hours to produce 2 witness statements in effect is grossly excessive. Large parts of Mr. Braganza's witness statements, for example, are just commentaries or recitation of what emails say, which is not properly evidence at all. It could simply have referred to the exhibits. So it would appear that a very significant amount of time has been spent simply reciting factual narrative in circumstances where that was unnecessary. Again, in that category, there's no reason why a partner needs to spend 3 hours and 48 minutes reviewing such a witness statement. That time could be minimised by a senior associate undertaking that work. And
well,
then
I suppose it could hold on. I suppose it could be said that if it's Mr. Braganza's own statement, then he should be paying more attention to it than otherwise a supervising solicitor would.
That could be said about any partner solicitor, any partner's witness statement, which is the usual way things are done in the DIFC. But there's no reason why the underlying work can't be done by a senior associate to be followed up by a review, which wouldn't take 3 hours and 48 minutes to review a 15-page witness statement, which, as I say, largely recites factual narrative in emails. And then in relation to my learned friends fees in my submission, a brief fee or fees of about £10,000 for somebody who's 2020 call, or indeed, as I understand it, 26 even more junior in the DIFC is 2 years call in the DIFC is grossly excessive. Just by way of comparison, my brief fee was only £7,000 for today's hearing. So I would ask your honour to assess that down as well to be more consistent with his level of experience.
£7,000 is what in dollars? About 10, isn't it?
I can do the maths, but if you want, while Mr. Marambone makes his submissions.
Okay, all right. Yes, Mr. Marambone, what you got to say about
well, yes, the partner time point of my learned friends are red herring. Mr. Braganza's and Miss Saxena's rates claimed are the same, 650 USD. So that doesn't go to the assessment of costs at all. And as your lordship rightly pointed out, he should spend more time if it's his own statement. So the idea of spending too long on witness statements, I don't accept that 26 hours to do these two very work on these very two detailed witness statements with detailed and lengthy exhibits is an unreasonable or a long amount of time to spend. It's in circumstances where there was obviously a lot of communications, a lot of separate sort of acknowledgements of the debt, or to piece through and to take the court through, and then subsequent communications with lawyers in different jurisdictions. There's a lot of material that had to be understood and condensed down. I've just been told, by the way, that the 650 rate, the reason it's a blended rate, but that's why I'm told that it's 650 for both of them. But the point is, it's the same point. They have the same rate. On the final point on my brief fee, that's not right. Now, I accept it's not broken down on the statement of cost, but that figure, I think it's £9,900.
But it looks to me as though it must combine a brief fee and some work on documents or something, because otherwise £995,625 wouldn't make any sense.
Exactly. It's just the brief fee was 7,500, so very similar range to my learned friend. I don't accept that our differing levels of call are relevant to that assessment. It's simply the nature. It's what's appropriate for this hearing. So it's very similar to my learned friend. Potentially slightly more work as having to respond and so on. The rest is work on documents. I'd suggest that figure is reasonable.
What about two solicitors attending the hearing? That's usually regarded as problematic.
Well, is it? I mean, Miss Hook is a paralegal, isn't she? She's a great. So she is. Let me just. Yeah. So she's a paralegal. So I say that's probably less. It is probably appropriate for Mr. Braganza as the person who's got conduct of the matter and who has given the witness statement, but then also for there to be some support from somebody who's at a much lower rate.
Thank you. Anything in reply?
No, I don't think so. I think I've made my submissions.
Thank you very much. The issue I now have to determine is the immediate assessment on the indemnity basis of the cost claimed by the defendant in relation to the application. In relation to the application to withdraw the set-aside application made by the defendant. The first issue which arises concerns whether or not the rates claimed are in excess of what is reasonable, because this is an assessment on the indemnity basis and therefore proportionality does not come into play. The rates are manifestly reasonable, and I say no more about that. The second point which was made was that the amount of partner time which has been expended on various attendances was in excess of what is reasonable. The response to that was that the rates charged by Miss Saxena, the senior associate, is the same as that of Mr. Braganza, the partner. Therefore, if this point is to go anywhere, it would be necessary to say that the aggregate number of hours expended on particular attendances of Mr. Braganza and Miss Saxena was in excess of what is reasonable. Turning first to the attendances on the it's left blank, but I think it should be attendances on the client. 4 hours of attendance by Mr. Braganza in relation to an application of this sort is not unreasonable. Proportionality doesn't arise. I allow that as asked. Miss Hook is a paralegal providing support. It is a little less clear what a paralegal would be doing in relation to attendances on a client. And I make a modest reduction in relation to her involvement in that level to 2 hours. So far as attendance on opponents is concerned, the attendances by Miss Braganza and Miss Saxena are modest in the extreme and are allowed as asked. The attendances of Miss Hook at 7 hours 42 minutes have not been suggested to be unreasonable, and therefore I allow those as asked. Attendances on others, the total of attendances on others by Mr. Braganza and Miss Saxena are still under, albeit just under 5 hours. I consider that reasonable. What is a little less clear is what Miss Hook was doing for 13 hours 24 minutes in attending on others. In the absence of an explanation in relation to that, I consider that to be a figure that stands out as potentially unreasonable, and doing the best I can on a broad brush basis on an immediate assessment, I reduce that to 9 hours. So far as work done on documents are concerned, there is criticism of the time which has been spent in total on what are 2 witness statements for Mr. Braganza. 2 points arise, or at least 2 points arise. First of all, Mr. Braganza, the senior associate, had no involvement in this part of the work. Secondly, therefore, the drafting exercise was carried out by a paralegal, Miss Hook, who took 26 hours to do the work. I accept the submission that that is in excess of what is reasonable, but albeit not by much, and I reduce that to 20 hours. So far as Mr. Braganza's involvement is concerned, whilst the time which might be taken by the partner with client responsibility for a case in relation to reviewing the witness statements of others might arguably have taken less time than 3 hours 48 minutes. Mr. Braganza was entitled to take slightly more time, given that it was his witness statement that he was being asked to sign. Furthermore, 3 hours 48 minutes for reviewing 2 witness statements does not strike me as in excess of what is reasonable, and as I've said, proportionality doesn't arise. Therefore, with the modest reduction in relation to Miss Hook's time, I allow Mr. Braganza's as asked. So far as attendances at the hearing are concerned, in the normal way, one would expect a senior associate to attend upon experienced counsel conducting a short interlocutory application of this sort. However, no particular objection was taken in relation to Mr. Braganza attending. And as it seems to me, that was appropriate, not least because he was the deponent of the two witness statements that he had given. The only question is whether or not I should allow the attendances of Miss Hook. Had proportionality been in issue, I would have considered that would have been it would have been disproportionate for two fee earners to be involved on an application of this sort being presented by experienced counsel. But I'm not prepared to conclude that her involvement was unreasonable in those circumstances. I allow that as asked. With those, the only other point that arises concerns counsel's fees. So far as that is concerned, the sum claimed is $1,133.54. So that is, and the point that was made was that that was in excess of what was reasonable for a brief fee of counsel's call in relation to an application of this sort, and was out of step with the £7,000 brief fee that had been agreed for the claimant. So far as that is concerned, upon analysis, the brief fee breaks down into £7,500 for the brief fee, with the remainder being in relation to work done on documents and other work in connection with the case. I can't conceive that that is unreasonable, and it's not necessary to speculate on what might have been the position had proportionality been relevant. In those circumstances, I allow the brief fee as claimed. Therefore, with those modest adjustments, I immediately assess the costs due from the applicant defendant to the claimant. Right. Any other business?
The only other matter arising is I've been instructed to ask that the time for payment of those costs be 28 days from today, on the basis that my instructions are that the money has to cross borders, and my client doesn't want to find itself in a situation where there's been a delay, which then leads to complaint that as a result of the need to transfer money in that way, and therefore asks the court's indulgence for an additional 14 days from the standard amount to ensure that payment is made in compliance with your owner's order.
Does this involve transferring money from the UAE to the UK? Is that the point, or the other way around?
I think it may. Well, I think it's the other way around. It's either from the UK. My solicitors instruct me that it's from the UK or the US to the UAE, and that would take potentially longer than 14 days to arrange and to be completed. Those are my instructions.
Right. Okay. Yes. Response to that?
Well, I'm instructed that it usually takes 2 to 3 working days, but in any event, the claimant would be prepared to accept payment in London instead of the UAE if that obviated the problem. To be very clear, my lord, it's been requested that there be a debarring provision so that if these costs aren't paid on time, then the defendants, I think that's accepted, the defendant's not permitted to pursue its further set-aside application. A delay of 28 days would disrupt the sort of carefully calibrated timetable that has been put in place.
To clarify,
but 14 days wouldn't, presumably.
Exactly, my lord, because that would come 7 days before the claimant would be due to file its own evidence in response.
To clarify, my further instructions are that the payment would be coming from India to the UK, and even if it was from India to the payment was being received in the UK, there would still be the potential for delay in a payment being made from those two jurisdictions. Those are my instructions.
I accept that it's more difficult to make payments out of India. All right. I'm going to direct payment in 14 days, liberty to apply for a further extension.
I'm grateful.
And what have you got to say concerning debarring, if anything?
Insofar as a debarring order, I understood our discussions earlier to be, as Mr. Baum suggested, which is
Yes.
that there would be a debarring order. That was my
Well, I just wanted to be
understanding.
sure that. But thank you. I just wanted to be clear that that was your understanding. Right. So 14 days. If not paid, then debarred. But liberty to apply for an extension of time in which to pay, providing any such application is made before the expiry of the 14-day period. Right. Anything else?
Not from me, Your Honour.
Thank you very much, Mr. Hogan.
I'll just double check, Your Honour.
Yeah, that's fine.
Nothing else, thank you, Your Honour.
Thank you very much. If you draw up an order and submit it to the registry in the usual terms, it will be processed appropriately.
I'm grateful.
Right.
Thank you, Your Honour.
Thank you very much.
Thank you.
Good day.
Thank you.